Thank you. I have pleasure in seconding the motion, and I should say that I'm neither an advocate nor a parliamentarian, merely a jobbing academic, and as may be relevant, Scottish academic, so I apologise in advance if my debating style is unpolished. It's already been established that the issue is correct, properly put, not written, but codified constitution. Much of what is undoubtedly constitutional is, of course, written. The Acts of Union 1707, the Parliament Acts 1911 and 1949, the European Communities Act 1972 as amended, the various Representation of the People and Parliamentary Constituencies Acts are undoubtedly constitutional. They define the boundaries of the state, who is entitled to vote, what counts as valid law, limitations placed on parliamentary sovereignty by UK membership of the European Union. Nothing could be more constitutionally fundamental, and the same could be said of the Human Rights Act and the devolution statutes. Some formerly unwritten conventions are also now written, which is a huge improvement for transparency and democracy. In 1950, the King's private secretary wrote an anonymous letter to the Times about the circumstances in which the monarch might refuse a dissolution to the then fragile Attlee Labour government. The pomposity and secrecy of this letter are quite astounding. I've not got time to quote it, but it's in my recent book or rant, What's Wrong with the British Constitution, on which I would say I take a fundamentally similar line to Richard's, but starting from a quite different point. Now, instead of anonymous letters to the Times, we have a publicly available cabinet manual presented before the election to a Commons committee by the Cabinet Secretary Sir Gus O'Donnell. On the same point, it makes it plain that the monarch is at all costs not to be drawn into party politics. If a government falls in mid-term, a situation that could be more relevant now and which I think Sir Gus and his colleagues saw potentially coming, the politicians must decide among themselves whether there is an alternative governing majority in the Commons, rather than pass the buck to the monarch. On this, I believe that Sir Gus had the awful warning of Australia 1975 in mind, when the Governor-General sacked the Prime Minister and appointed the opposition leader in his place. He was acting, I think, in a way which was consistent with the anonymous advice of the King's Secretary 25 years earlier, but he probably killed the monarchy in Australia in the long run. So, Sir Gus's public manual is vastly better than the King's Secretary's anonymous letter, but it's still unsatisfactory. It's never been voted on. It's still a work in progress. We're clearly some way short of, let's say, the US Constitution. Those of us who favour a codified constitution, therefore, really favour two things. One, that all constitutional conventions should be hauled into the light of day. And let's get away from a famous saying of 1904, we live under a system of tacit understandings, but the understandings themselves are not always understood. Two, that constitutional legislation should be distinguished from ordinary legislation by being more difficult to enact and to repeal. Some constitutional legislation has been put in front of the people, as I would argue the Parliament Act 1911 and the Abortive Government of Ireland Act 1914 were. So were the current devolution statutes in all three of Scotland, Wales, Northern Ireland. Other such legislation was put up for referendum only after enactment, e.g. the European Communities Act 1972, or not at all, e.g. the Human Rights Act. So, what form should entrenchment take, and should it exist at all? Sir Christopher's point against entrenchment is essentially that it's anti-majoritarian, I believe that is his view, and that the uncodified constitution has done us all right. I haven't got time to deal with the second argument, but I have a very detailed account in my book of how the British Constitution came very close to collapse in the years 1911 to 14, and landed us, I maintain, with the tragedy of Ulster, which lasted from 1914 until very recently. So I'm afraid I don't buy that argument. Entrenchment, however, undoubtedly removes power from Parliament, which is characterised by those who dislike entrenchment as the representatives of the people and hands it to unelected judges. A blatant problem with this argument is that the current Parliament, to a lawyer, comprises 3 chambers, only one of which is elected by the people. So equating parliamentary sovereignty with popular sovereignty won't work. Nevertheless, the critics have a point when they say that entrenchment is counter-majoritarian, and I think the happy medium here was suggested by Lord Leicester, the eminence grise of the Human Rights Act 1998. That Act, unlike the European Communities Act, does not empower the courts to strike down legislation. Courts are required to read statutes as far as possible in a way which complies with the European Convention on Human Rights. When they cannot, they may issue a declaration of incompatibility. Parliament may then decide whether or not to amend the offending statute. This preserves not parliamentary sovereignty, but at least what has been called comity between Parliament and the courts. If I had my way, constitutional statutes, such as those that I've mentioned, and such as, for instance, the Cabinet Manual, would be dealt with under what, let me call, the Leicester Convention, in other words, treated analogously to the Human Rights Act. Then I would be content with the codified constitution of the UK, and I hope that Richard and I have persuaded you to be as well. Thank you.